Thank you. Welcome everybody to the semifinals of the 2022 Santa Cruz County High School Mock Trial Competition. I'm Judge Coliati, and I would like to invite our student bailiff to please call the court to order.
Before calling the court to order, I would like to remind all participants that there will be no use of cell phones allowed during this trial. In addition, your camera must remain off and your microphone must remain muted unless you are actively presenting. With that being said, the Superior Court of the State of California, County of Santa Cruz, Department 1 is now in session. Honorable Judge Coliati presiding.
Thank you, bailiff. And again, welcome to everyone. I know we have 2 teams worth of students who have worked extremely hard over many months to get to this place. Congratulations to all of you for getting to the semifinals. A big thanks to everybody who supported them, starting with their mock trial coaches who are here tonight and put in countless hours of their time. Thank you to the parents who supported these students during this time as well. And I'm glad that many parents can be here to watch tonight. This is such an honor to preside over the semifinals. High school mock trial, I think, is the highlight of many a judge's day, and we're very pleased to be able to host it. We'd be a lot more pleased if you were here in the courtroom with us, but thank goodness for technology that we can make this happen in a safe environment for everybody. We hope to see you live here next year. I want to invite everybody to remain relaxed. You're all in your homes. I think the last trial I presided over, the biggest feedback we gave to everybody was to slow down and relax. When I'm actually using Zoom like this in the courtroom, we have a live court reporter here taking things down, and it's so important for anyone appearing on Zoom to speak loudly and clearly and slowly, both so that they can be understood, but also for our court reporter. Now, of course, there's no court reporter for mock trial, but the same admonition really is true. So everybody take a big breath, slow down and relax, have fun. This is going to be a great experience. And so let's start off with introductions from each team. I'd like first for the prosecution team to introduce themselves for me and for the attorney scorers.
Good evening, Your Honor. My name is Chance Hosler, H-O-S-L-E-R, pronouns he, him, and I will be arguing the pretrial motion for the people of the state of California. May my co-counsel please introduce themselves?
Yes, please.
Thank you.
Good evening, Your Honor. My name is Elise Garza, G-A-R-Z-A, pronouns she, her, representing the people of the state of California in this action. I will be conducting the direct examination of Angel Russell and the cross-examination of Francis Yazzie. I will also be presenting the opening statement.
Good afternoon, Your Honor. My name is Nicola Hall, H-A-L-L, pronouns she, her, representing the people of the state of California in this action. Today, I'll be conducting the direct examination of Dr. Charlie Dunn and Deputy Sheriff Tony Garrett, and the cross-examination of Dr. Tyler Clay and Danny Emling.
Good evening, Your Honor. My name is Mira Narayan, N-A-R-A-Y-A-N, pronoun she, her, representing the people of the state of California in this action. Today, I'll be conducting the direct examination of Terry Edwards, as well as the cross-examination of the defendant, Jamie Kobe. I will also be presenting the closing argument. At this time, may our witnesses please introduce themselves?
Please.
Thank you.
Good evening, Your Honor. My name is Samuel Attard, A-T-T-A-R-D, pronouns he, him, and I'm Angel Russell.
Good evening, Your Honor. My name is Stella Guthrie, G-U-T-H-R-I-E, pronouns she, her, and I am Deputy Sheriff Tony Garrett.
Good evening, Your Honor. My name is Cora Fisher, F-I-S-H-E-R, pronouns she, her, and I'm Terry Edwards.
Good evening, Your Honor. My name is Mara Christian, C-H-R-I-S-T-I-A-N, pronouns she, her, and I am Dr. Kai Chavez. At this time, may our court clerk please introduce herself?
Yes, please.
Good evening, Your Honor. My name is Polina Doronkina, D-O-R-O-N-K-I-N-A, and I will be your court clerk. At this time, I would like to remind the court that I will be using visual and verbal symbols for when the time left is 2 minutes, 1 minute, 30 seconds, as well as it is when it is time to stop. At this time, may our attorney coaches please introduce themselves?
Yes.
Mary Fukai, attorney coach. Good evening.
Good evening.
Lazarus, advisor.
Thank you. Is that it for Team J?
Yes, Your Honor.
All right. Thank you. Defense team, please introduce yourselves.
Good evening, Your Honor. Scoring attorneys, we are Team D, presenting the defense side. My name is Mia Beatty, that is B-E-A-T-T-Y, with the pronouns she, her. I will be presenting the pretrial motion as counsel for Mr. Jamie Kobe. At this time, may my co-counsel please introduce themselves?
Yes.
Good evening, Your Honor. Scoring attorneys, my name is Nicholas Barrett, B-A-R-R-E-T-T. My pronouns are he, him, representing my client, Mr. Jamie Kobe. Tonight, I'll be conducting the direct examination of Danny Emling and Jamie Kobe, as well as the cross-examination of Deputy Garrett. I'll be presenting the closing argument for the defense as well.
Good evening, Your Honor. Scoring attorneys, my name is Samantha Wickham, spelled W-I-C-K-H-A-M, with the pronoun she, her. Tonight, I will be counsel for the defense representing my client, Jamie Kobe. I will be conducting the direct examination of Dr. Tyler Clay, as well as the cross-examinations of Terry Edwards and Dr. Charlie Dunn.
Good evening, Your Honor. Scoring attorneys. My name is Isaiah Navarro, spelled N-A-V-A-R-R-O. Pronouns he, him. Counselor for the defense, representing my client, Jamie Kobe. Tonight, I will be conducting the opening statement as well as the direct examination of Francis Yazzie and the cross-examination of Angel Russell. At this time, may our witnesses please introduce themselves?
Yeah. Yes, please.
Thank you.
Good evening, Your Honor. Scoring attorneys, my name is Jocelyn Castillo, that is C-A-S-T-I-L-L-O, pronouns she, her. Tonight, I will be portraying Francis Yazzie.
Good evening, Your Honor. Scoring attorneys, my name is Aidan Bajan, spelled B-A-J-A-N, with the pronouns he, him, and I'll be portraying Danny Emling.
Good evening, Your Honor. Scoring attorneys, my name is Malia Marino, spelled M-O-R-E-N-O, with the pronouns she, her, and today I'll be portraying Dr. Tyler Clay.
Good evening, Your Honor. Scoring attorneys, my name is Aaron Buchanan, spelled B-U-C-H-A-N-A-N. My pronouns are he, him, and tonight I will be portraying Jamie Kobe. At this time, may our bailiff introduce themselves?
Yes.
Good evening, Your Honor. Scoring attorneys, my name is Ronya Eilfort, spelled E-I-L-F-O-R-T, with the pronouns she, her, and I will be your bailiff this evening. At this time, I would like to remind the court once again that there will be no use of cell phones allowed during the trial, and that your camera must remain off and your microphone must remain muted unless you are actively presenting. At this time, may our teacher coaches please introduce themselves?
Yes.
Good evening, Your Honor. Scoring attorneys, my name is John Tiffany. I'm the teacher advisor for this team.
Good evening, Your Honor. Scoring attorneys, my name is Christine Solomazian, and I am the attorney coach for this team, and that should complete the introductions for Team D.
Thank you so much. All right. So as you all know, this is what we call a bench trial. It's not a jury trial, it's a trial to the court. And at the end of this trial, I will render a verdict of guilty or not guilty in relation to the charge brought. The teams will be rated based on the quality of their presentation, independent of my verdict. At this point, we are going to begin with pretrial arguments. Both sides have 4 minutes to present their arguments. The defense will go first. I will interrupt to ask clarifying questions. Time spent answering my questions is not included in the 4-minute time limit. At the conclusion of your arguments, each side will be offered 2 minutes of rebuttal time. Remember that the rebuttal time is to be used to counter your opponent's arguments. It cannot be used to raise new issues. Is counsel for the defense ready to begin?
Yes, Your Honor, the defense has a motion to suppress. May I proceed?
Please.
Your Honor, the defense moves that the court grant the motion to suppress all images surveilled from the video recordings of Mr. Jamie Kobe's yard obtained on April 29th on the basis that my client's Fourth Amendment right to be secure in his own private property against means of unreasonable search was violated by Deputy Tony Garrett. On October 10th of 2020, Deputy Garrett provided Mr. Eric Smith with a smart camera belonging to the Sheriff's Department to survey Mr. Kobe's property with. Deputy Garrett instructed Mr. Smith on where to place the camera, which was installed on a 10-foot pole at an angle that circumvented not only Mr. Smith, but Mr. Kobe's 6-foot-tall wooden fencing, allowing full visibility into his yard. Deputy Garrett also showed Mr. Smith how to adjust the sharing settings to link directly to the Sheriff's Department at any given moment. This intensive 6-month surveillance was in fact a violation of my client's Fourth Amendment right due to several criteria based on objective standards of reasonability and privacy established in relevant federal court cases. These criteria include Mr. Kobe's yard being private curtilage, his subjective and reasonable expectations of privacy being violated, and the intensive 6-month duration of the surveillance. First, the objective standards for curtilage through the 4-part test established in the federal case of U.S. v. Dunn were fulfilled. Mr. Kobe's yard was adjacent to his home, was relatively small, and could have only been reasonably used as a private yard, had 6-foot-tall wooden fencing entirely enclosing it, preventing visibility, and Mr. Kobe attempted to stop the surveillance by confronting Mr. Smith about the camera. This fulfilled all 4 parts of the curtilage test, establishing his yard as a private extension of his home, deserving of equal rights and protections.
Counsel, I have a question.
Yes,
As we know, this fence was solid most of the way around, but it was open at the back. Under the case law, is that relevant in deciding whether it's curtilage?
No, Your Honor, because the slight amount of visibility that is, perhaps you're referencing the open view principle in Katz v. US. The previous establishment of curtilage refutes the open view principle because the entirety of Mr. Kobe's yard was deserving of private protections because it was surrounded and had the intent of protection from the 6-foot wooden fencing. The small amount of visibility from the fence gate was the result of, material rather than any sort of lack of care to protect the property. The open view principle is only enacted and only comes into play when the individual's property has a lack of care or a lack of protection in place. Does that answer your question?
Thank you. You may proceed.
Thank you. What further upheld this surveillance as a violation of Mr. Kobe's rights to privacy were his subjective expectations of privacy that society views as reasonable, established in Katz v. US and US v. Jones. Mr. Kobe established this in a number of ways, most notably by explicitly telling Mr. Smith that he, quote, did not have permission to point the camera into his yard, end quote. Furthermore, my client's reaction to the camera being present was in response to believing it was purely the act of his landlord, an extension of their numerous petty disputes. This merely was an instance of my client placing trust into his landlord, as it was unbeknown to him that the camera was sheriff's property, the footage was being fed directly to the Sheriff's Department in a searchable format, and that as a result of this, Mr. Smith was acting as law enforcement.
Counsel, I have another question, please.
Yes, Your Honor.
How is this camera that's up in the air any different than the flyovers that didn't require warrants in cases such as Serralo and I guess in Dunn as well, it was an aerial photo, but particularly Serralo.
The main distinction between my case and Serralo was that the emphasis on the ruling of Serralo was the fact that the plane glanced down into the property. The information was gathered through mere seconds of passing by and glancing down, rather than any sort of unending, permanent, stationary surveillance, like in my client's case. The placement of the sheriff-owned camera was not equatable to a mere glancing, because of the positioning and the extensiveness of the surveillance from October 10th to May 2nd that lasted over 6 months. The intensive duration of the surveillance established in cases like People v. Weaver and, People v. Weaver and US v. Jones adds another certain level of intensity and provides far more violation of the individual's property. So this provided any more surveillance and more data than a sort of mere glancing or passing by could have provided the Sheriff's Department. Does that answer your
you.
question?
Yes, you may proceed.
Thank you. Mr. Kobe's expectations of privacy, despite his knowledge of the camera, were still present because Mr. Smith was acting as law enforcement and because he did not know the full extent to which his property was being surveilled by the sheriff's department. As well as this, Mr. Kobe's subjective belief of privacy, the layout of desert towns involves more spread out properties as well as fewer people walking by homes and yards, unlike an urban neighborhood. Because of this, Mr. Kobe's enclosed yard was separated from Mr. Smith and other tenants' properties. Mr. Kobe had the reasonable expectation that people were not frequently walking past, nor were they going to any extent to look into his enclosed yard for a long duration of time. And finally, the duration of the surveillance must be taken heavily into account, as established in Schaefer v. City of Boulder, People v. Weaver, and US v. Jones. The 24-hour surveillance that lasted over 6 months in my client's case violated means of warrantless investigation and further intensified it. It provided law enforcement with data to search through later when needed. My client, Mr. Jamie Kobe's yard, was in fact private and was in fact an extension of his home, deserving
30
of
seconds
reasonable
remaining.
means of privacy, and was, as a result of this, unlawfully searched. For these reasons, I asked the court to grant the motion and find that the images obtained by the sheriff's camera directed at Mr. Kobe's property for over 6 months of unending surveillance should be suppressed as a violation of my client's Fourth Amendment right. Thank you.
Thank you. Is counsel for the prosecution ready to begin?
Yes, Your Honor. May I begin?
Yes.
Good evening, Your Honor. Today, I ask you to deny the defense's motion to exclude Exhibit A, Kobe's snake feeding tongs, under the Fourth Amendment. The Fourth Amendment only protects against unreasonable search and seizure. As you will hear today, Jamie Kobe's Fourth Amendment rights were not violated. The case of Katz v. US gives us a framework with which to view the Fourth Amendment: reasonable expectation of privacy. In order for a search to have violated the Fourth Amendment, there must be an objective expectation of privacy, or what a reasonable person in the defendant's position would have believed, but the defendant must also have shown a subjective expectation of privacy. Evidence left in plain view is not protected under Katz v. US because it shows a lack of subjective expectation of privacy. And Your Honor, the snake feeding tongs were in plain view. Jamie Kobe's residence was bordered by public land. The chain link gate towards which the camera was pointed was 4 feet high. Any passerby walking through the public land between Kobe and Smith's residences could have seen the snake feeding tongs at a quick glance over Kobe's chain link gate. The cases of US v. Not. Were you saying something, Your
I'm
Honor?
sorry, counsel, may I interrupt and ask a follow-up question on that, please?
Of course.
So, I mean, here we have someone whose backyard is fenced in by a 6-foot-high fence on almost all sides except the very back and just the gate part of the back. Doesn't that show a subjective expectation of privacy? And if not, what's your best case for that?
Well, Your Honor, the fact that there was a gate that was open towards which the camera was pointed that people could have seen through shows a lack of subjective expectation of privacy. So if we if we look at the case of Schaefer v. City of Boulder, we can see in that case that the defendant was also aware of the camera like Kobe, and they took action to have the camera removed. Kobe simply asked Smith to take down the camera once. However, the defendant in the case of Schaefer v. City of Boulder talked to his neighbors multiple times, called the police, and actually went to the extent of heightening his fence in order to prevent the observation of the camera. Unlike Kobe, who was aware of the surveillance and had called the police on Smith multiple times over really small things like noise violations, but did not call the police over this camera that they apparently did not want pointed at their property. And if Kobe had a subjective expectation of privacy, they would have taken greater steps in order to have the camera taken down.
Okay, I'm not sure that you answered my question exactly. I guess what I'm asking is, in light of the fact that almost all the property is surrounded by this fence that can't be seen through, how does that weigh in determining whether there's a subjective expectation of privacy when there's just a small portion that can be looked into, and presumably somebody in the backyard area wouldn't be watching over that small gate for 24 hours a day?
Well, Your Honor, if Kobe had not wanted the snake tongs or the yard in general to be viewed, why would there be a portal through which the gate one could view the backyard? It is entirely possible to install a fence that is not see-through like a chain link gate. If Kobe did not want the snake tongs to be visible, they could have put it in the home towards which the camera was not pointed. And again, Kobe had an awareness of the camera separate from any theoretical person walking through the area, and they did not move the snake tongs being aware of that camera.
All right, thank you. You've answered my question now. You can proceed with your argument.
Thank you, Your Honor. The cases of US v. Knotts and California v. Cirolo give precedential validity to this idea by telling us that information gained through technology that could have been performed visually or by any member of the public is not a violation of the Fourth Amendment. The case of US v. Dunn brings up the issue of curtilage. While the prosecution concedes that Kobe's backyard was within the curtilage of his home, this does not mean that an unconstitutional search occurred. Kobe did little to protect their backyard from observation, and no officers entered their backyard, as in the barn in US v. Dunn, which states that even if there is a reasonable expectation of privacy within a space, that privacy is not violated if no officer enters the space in question. Thank you, Your Honor. Please deny the defense's motion to exclude Exhibit A, Kobe's snake feeding tongs.
Thank you. Does the defense have a rebuttal?
Yes, Your Honor. May I proceed?
Yes.
Thank you. Your Honor, my client's yard was a private extension of his home, fulfilling all four parts of the US v. Dunn case, and was unlawfully searched due to not only my client's expressed belief in his subjective privacy, but also due to the extensive duration of the surveillance. Further on this point of subjective beliefs of privacy, what is emphasized in cases such as Katz v. US and US v. Jones is the individual showing a reasonable expectation of privacy in the item or place at hand. My client explicitly told Mr. Smith that he did not consent to the camera footage, and my client had a reasonably protected yard in place.
Counsel for the prosecution brought up the Schaefer case, and I wanted to ask you whether the differences between this case and Schaefer are significant. So first of all, in Schaefer, the defendant there not only asked for the cameras to be removed, but actually called the police and added to get the cameras removed and added a fence to prevent the camera from looking into the yard. And then also in that case, the cameras were a very special, high quality type of camera, unlike the cameras in this case, which could be purchased by anyone. So can you address those two factors that played into the Schaefer decision and whether they're significant?
Yes, Your Honor. Although in the case of Schaefer v. City of Boulder, Schaefer went to a greater means of suppressing the surveillance at hand, it is not mentioned in the case or any cases at hand today that the individual being surveilled has to work to a certain extent to suppress the surveillance. My client verbally and very explicitly expressed to Mr. Smith that he did not consent to the camera in place and had reasonable expectations of privacy that he was upholding in doing so. And he would have those protections as a result of that still. And then moving on to the point regarding technological advancements, the camera being unavailable technology, that what you mentioned. Technological advancements, as mentioned in cases such as People v. Weaver, have evolved greatly in the modern era to be able to take surveillance in invasive ways beyond whether or not they're available to the public or whether they're just available to law enforcement. The precedent set in cases like Kylo v. US are not necessarily applicable today because the camera at hand was used for an extensive duration that provided such a large amount of data and a large amount of surveillance of my client's yard that it was just as, if not more, invasive as any sort of technology that would be only available to the sheriff's department. And further, because my client's yard was in fact private curtilage, the duration, as I mentioned, and because he had that individual expectation of privacy he expressed to Mr. Smith, it would therefore be still a violation of his private rights and protections. Does that answer your question, Your Honor?
Sure, please proceed.
Thank you. My client's yard was close to his home, was enclosed entirely, had fencing surrounding it, and he expressed a reasonable expectation of privacy. In the cases of Schaefer v. City of Boulder and Romero v. Bustamante, For Schaefer, the fencing was only 4 feet tall and could have been easily looked over, yet it still constituted the US v. Dunn curtilage test. And Rivera v. Bustamante, the fencing was made of a chain link material. Regardless of
1
this,
minute.
both yards fit the requirements of the Dunn curtilage, as did Mr. Kobe's, overriding any sort of argument regarding the chain link fence at hand. Further, opposing counsel brought up the precedent set in California v. Cirillo. However, what is emphasized in that case is the importance of how the plane glanced down into the yard. Temporary surveillance. My client's yard was extensively surveilled for 24 hours, a 6-month period, endlessly, and was made available to the sheriff's department.
30 seconds remaining.
For these reasons, I ask the court to grant the motion to suppress all images surveilled from the video recordings of Mr. Jamie Kobe's yard on the basis that my client's Fourth Amendment right to be secure in his own private property was violated by Deputy Tony Garrett from this extensive surveillance. Thank you, Your Honor.
Thank you. Does the defense have a rebuttal argument?
Yes, Your Honor. In responding to the defense's argument, we must return again to the seminal case of Katz v. US, and specifically the defendant's subjective expectation of privacy, or rather the lack of it. Your Honor, Kobe was aware of the camera and they did not call the police. These are the material facts of this case. Kobe called the police on Smith over noise violations frequently, over their plants, over smaller things than an actual believed violation of their privacy. If Kobe's privacy was truly violated by this camera, why did they not call the police? Additionally, responding to opposing counsel's claim that because Kobe did not know that the camera had been provided to Smith by the sheriff, that Kobe was not aware of the violation of their privacy that they claim occurred. Kobe and Smith had a very contentious relationship. Smith had also called the police on Kobe multiple times over small offenses. Kobe knew.
Counsel, I'm going to interrupt you again. We've talked a lot about the subjective or actual expectation of privacy prong of Katz, but I think counsel for the defense focused also on the reasonable expectation prong of it. And I wanted to ask you a question about that. The cases that involve the flyovers, such as Cirillo and Dunn, counsel for the defense pointed out, those were brief observations. Don't the cases involving the more extensive surveillance, such as Jones and Weaver, suggest that if there's a 24/7 surveillance, it does violate that reasonable expectation of privacy that we all have?
Thank you, Your Honor. I was about to address that next. In this case, although the camera was up for a few months, the period of footage that was actually reviewed by the police was 1 day. Now, one could argue that because the camera was up for those months, it counted as a longer duration of surveillance. However, the police did not actually review that period of the camera footage. The police could technically have also entered Kobe's property at any time, but we're focusing on the material facts of what the police actually did in this case. So the surveillance in this case is more comparable to in the case of US v. Knotts, which was a shorter duration of surveillance and was not considered to be an unreasonable search.
Thank you very much.
Thank you, Your Honor. Please deny the defense's motion to exclude Exhibit A, Kobe's snake feeding tongs.
All right, thanks to both counsel. Before I rule on the motion, students may confer with their attorney coaches or teacher coach regarding any irregularities. I'll give you a few seconds to let me know whether you'd like to do that. Would the prosecution team like to note any irregularities?
No, Your Honor. Thank you.
Thank you. And how about the defense team?
None, Your Honor. Thank you.
All right. Thank you. All right. In this action, I am going to deny the defense motion to suppress. The photos of the snake tongs will be admissible at the trial. So we can proceed to the trial portion. And first of all, does either the prosecution or defense have any physical evidence that they would like to present for inspection?
Yes, Your Honor. The prosecution would like to pre-mark exhibits A through E for identification.
Thank you. We will do that virtually.
Thank you.
And how about defense?
None, Your Honor.
All right, thank you. So here's the charges. The people of the state of California are charging the defendant, Jamie Kobe, with first-degree murder or voluntary manslaughter of Eric Smith. It's time for opening statements. Prosecution, are you ready?
Yes, Your Honor. May I proceed?
Yes.
For the convenience of the court, my name is Elise Garza. Revenge is a powerful motive. Jamie Kobe murdered Eric Smith because he held him responsible for his mother's death. The evidence will show that Eric Smith's death was not an accident or a coincidence. It was not heat of passion. It was a premeditated, deliberate, and willful murder. Jamie Kobe and his mother had been renting a house from Eric Smith for about 10 years. Kobe's mother was in ill health and was on an oxygen machine. The landlord-tenant relationship between Kobe and Smith was contentious. The defendant could not pay his rent during the pandemic, and Mr. Smith could not legally evict him. Mr. Smith began to randomly turn off the electricity. On April 22nd, Mr. Smith again shut off the power to the defendant's home, cutting off the power to his mother's oxygen machine. Miss Kobe went into respiratory distress and died. We know the defendant blamed Mr. Smith for her death. At the funeral, he was heard screaming at the victim, "You killed my mom." The next day, Eric Smith was dead, bitten by a rattlesnake hidden in his mailbox. Angel Russell, a line worker for the utility company, working near the area on April 29th, will testify that around 8:30 a.m., he saw Jamie Kobe carrying a large, bulky bag in a metal animal cage. He repeatedly looked down at the cage as he walked to the victim's mailbox. When Mr. Russell last saw Kobe, he was still standing at the mailbox. At around noon the same day, Mr. Russell saw Eric Smith walk out of his residence to that same mailbox. Russell watched as Mr. Smith opened the mailbox door, reached inside, screamed, and withdrew his hand, a large snake hanging off of it. He will testify that he rushed over, killed the snake, and told the victim to seek medical care, but that Smith just went back inside. The next morning, when Russell returned to the job site, he found Eric Smith's body in his front yard. Deputy Tony Garrett conducted a thorough investigation. The deputy took the body of the dead rattlesnake into evidence and noted that it was 2 feet long and 2 inches in diameter, too wide to fit through the slot on top of the mailbox. In Mr. Smith's home, Deputy Tony Garrett found 3 envelopes containing rent checks from Mr. Smith's other tenants, but nothing from Jamie Kobe. The coroner, Dr. Charlie Dunn, will testify that the cause of death was the lethal bite of the Mojave rattlesnake found at the scene. Terry Edwards, a neighbor, will testify that she attended Miss Kobe's funeral. She witnessed the defendant scream at the victim, "You killed my mom." Later at dusk, she went by the defendant's home and heard the defendant yell, "I'm going to kill him." Miss Edwards told the defendant to get some rest, but Kobe said he had something to finish first. Miss Edwards also noted that it was unusual that Kobe was outside gardening at dusk, because everyone knew that's when snakes are most active. Everyone, including Jamie Kobe. He had lived in the desert for 10 years. He knew all about the Mojave rattlesnake, and he had all of the safety gear necessary for trapping and handling venomous snakes. Gloves, boots, a metal trap. He even had anti-venom. Your Honor, the evidence will prove beyond a reasonable doubt that only Jamie Kobe had the motive, the means, and the opportunity to kill Eric Smith. This was not a spontaneous, sudden quarrel or a violent outburst in the heat of passion. It was a meticulously planned and carefully executed murder in the first degree. Thank you.
Thank you. Is the defense team ready to present an opening statement, or would you like to defer it to the defense case?
No, Your Honor, you'd like to conduct our opening statement now.
All right, please
In the
proceed.
convenience of the court, my name is Isaiah Navarro. Your Honor, may we begin?
Yes.
A humble gardener, a teacher, a friend, and a loving son. Your Honor, my client, Mr. Jamie Kobe, is many things, but a murderer is not one of them. My client is accused of capturing a rattlesnake, somehow safely removing its rattle, then in broad daylight, unbeknownst to anyone, including a line worker working just 100 feet from Mr. Smith's residence, putting the rattlesnake into Mr. Smith's mailbox, supposing that even in this world of modern medicine, a rattlesnake bite would serve as an effective murder method. Now, while this whole situation may seem more like a teenager's poorly planned prank gone wrong, still, here we all are, and on trial before you, an innocent man accused of a crime that he did not commit. Your Honor, before the end of this trial, you will hear testimony from Danny Emling, a neighbor to Mr. Kobe who can attest to his common gentle nature. You will hear from Francis Yazzie, a dear friend of Mr. Kobe's, who will testify that after the funeral, my client maintained a level head and was not engulfed by rage like the prosecution would have you believe. You will hear from Terry Edwards, an expert witness and herpetologist who will not only testify to the real likelihood of a rattlesnake finding its way into a mailbox on its own, but also to the real unlikelihood of a rattlesnake bite being fatal given the wide availability of antivenom. Finally, you will hear from Mr. Kobe, whose testimony will serve to further defend what will have already been established. He is not a murderer or anything of the sort, but simply a son who wishes to grieve for his mother. Your Honor, my client stands charged with first-degree murder or voluntary manslaughter. Let us speak to the first charge. In accordance with Calcrum 521, the requirements for murder in the first degree are that the defendant acted willfully, deliberately, and with premeditation. The defendant acted willfully if they acted while intending to cause harm. However, as you will hear from Danny Emling, my client is a calm and gentle individual who would never willfully harm anybody else. The second requirement, deliberation, requires the defendant to carefully weigh their options and still choose to act, all while being certain of the consequences. However, as you will hear from our expert witness and herpetologist, Dr. Clay, it is simply impossible to be certain or aware to any extent of the consequences of putting a rattlesnake into a mailbox, given that the wide availability of antivenom makes death by rattlesnake bite very unlikely. The third and final requirement, premeditation, requires the defendant to think about and plan to act before committing it. However, as you'll hear from Francis Yazzie, after the funeral, my client laughed off and even dismissed the situation entirely. The unfortunate death of Mr. Smith took place an entire week after the death of my client's mother, and to now suggest that for an entire week, my client was plotting to commit murder with a rattlesnake, even after having already dismissed the situation, is simply illogical. The second charge of voluntary manslaughter requires the defendant to act in the heat of passion under direct and immediate influence of provocation without due deliberation. However, as you will hear in testimonies from both Danny Emling and Francis Yazzie, my client is not a man to act in the heat of passion, but a calm, collected, and gentle individual who, as will be expressed for Francis Yazzie, had calmed down and dismissed the situation after the funeral. Your Honor, in order for my client to be found guilty of either of these charges, the prosecution must meet their burden of proof. They must prove beyond a reasonable doubt that my client is responsible for the acts that resulted in the death of Eric Smith. However, you will see through the prosecution's presentation of unreliable witnesses, conflicting expert opinions, character evidence taking away my client's motive, no definitive account of what occurred that day, and copious amounts of evidence that point towards nothing more than a tragic accident, that the prosecution has not come close to meeting its burden. Thank you.
Thank you. All right, it's time for the witnesses. Prosecution may call its first witness.
The prosecution calls Angel Russell to the stand.
Calling Angel Russell to the witness stand. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you. Please state your name for the convenience of the court.
My name is Samuel Attard, Attard, and I'm Angel Russell.
For the convenience of the court, my name is Lace Garza, and this witness's statement can be found on pages 38 and 39. Mr. Russell, could you start by telling us where you work?
Yes, I've worked as a line worker for Bursley County for about 15 years.
Do you remember what you were doing on April 29th?
I was working on the power lines about 100 feet away from Eric Smith's house, number 46601. I was there on both the 29th and the 30th.
At this time, I will refer you to the exhibit marked for identification as Exhibit C. Is this familiar to you?
Yes, this is an aerial map of the crime scene.
Does this look like an accurate depiction of the area in which you were working on the 29th and on the 30th?
It does.
What time did you start work on the 29th?
Well, I went up the power pole at about 8:30 a.m.
When you were working that morning, did you observe anything unusual?
Yes, shortly after I started working, I saw a person wearing a long sleeve t-shirt and jeans walk out of 46603 and to the mailbox in front of 46601. I waved to them, but I didn't get a response, so I don't think they saw me.
Was there anything about this person that stood out to you?
Yes, they were carrying a medium-sized wired cage, and I saw them glance down at it a few times. They also had some kind of bulky bag.
Was there anything inside the cage?
I couldn't tell, but they kept looking down at it as they walked.
Did you observe when the person left the scene?
No, they were standing next to the mailbox when I went back to work.
Did anything else happen on the 29th?
Yes, around 12 p.m., I saw Eric Smith come out of 46601 and walk towards
Objection,
the
Your
same
Honor.
mailbox.
This question calls for a narrative response.
Overruled. The witness may continue their response.
Thank you, Your Honor.
Well, I saw them walk towards the same mailbox. I saw them open the mailbox and reach in and then scream away and back away from the mailbox, trying to shake what looked like a snake off of his wrist or hand.
Did you notice anything else at this time?
I saw a few envelopes falling to the ground.
What did you do next?
I climbed down from the pole and saw Smith on the ground moaning, and I saw it looked like a rattlesnake, but immediately I noticed it didn't have a rattle. So I killed it, and then I went back to assist Smith.
What was Smith doing at this time?
Well, while I was running back to kill the snake, Smith stood up and screamed, "Jamie!" He then started to walk away, seeming to be in a daze. I told him to stay still, and he sat on the ground next to the mailbox.
What happened next?
It was obvious that Smith was in a lot of pain, and I'd remembered seeing something on TV about sucking the venom out of snakebite wounds, so I tried to suck the venom out of his swollen arm, but I got mostly blood.
And then what happened?
Well, I urged him to go to the doctor, but he said it wasn't necessary and that he would just tough it out and ice it. Then he grabbed the envelopes that were on the ground and went inside, so I just left for the day.
The next morning, when you returned to the site, what did you see?
I came back at 8 o'clock the next morning to finish up, and I saw Smith in pajamas laying face down in his yard.
After finding Smith face down, what did you do?
I checked his pulse, but I couldn't find it, so I called for 911 immediately. I called out for help, but I didn't get a response.
When did help arrive?
The sheriff's car pulled up at about 8:40 a.m., and I told the deputy what I had seen on both the 29th and the 30th.
Thank you. No further questions at this time. And I ask that Exhibit C be admitted into evidence.
I'm sorry, which exhibits?
Exhibit C.
Exhibit C. Any objection from defense to admitting Exhibit C?
None, Your Honor.
All right, defense may cross-examine. And sorry, C will be admitted.
Thank you, Your Honor.
And thank you, Your Honor. For the convenience of the court, my name is Isaiah Navarro. Mr. Russell, you said that you were working on the power lines the morning of April 29th on Raptor Road. This is correct?
That's right, about 100 feet away from Eric Smith's residence.
And then you saw who you identified later as Mr. Kobe exit the address of 46603, correct?
Yes, wearing a long sleeve t-shirt and jeans whilst carrying a medium-sized wired cage and a bulky bag.
You would say that the address 46603 was a significant distance further from you than address 46601, correct?
I suppose I could say that.
Yet, despite this, you were able to identify Mr. Kobe carrying everything that you just aforementioned, correct?
Yes, I was.
Please, yes or no to the following questions. Did you see anything inside of the cage that Mr. Kobe was carrying?
No, I wasn't very focused on the cage.
Did you see Mr. Kobe take anything out of the cage?
No, all I noticed was that he was just kept on looking down at it.
And you did not see him take anything out of the bag?
Not that I can recall. I was very focused on my work.
Finally, you didn't see Mr. Kobe touch the mailbox at all?
No, I wish I'd paid more attention, but I didn't realize anything was wrong.
Okay. Thank you, Your Honor. No further questions.
Any redirect?
None at this time, Your Honor. May this witness please be dismissed?
Yes, the witness is excused. And the prosecution may call its next witness.
Your Honor, the prosecution calls Deputy Sheriff Tony Garrett to the stand.
Calling Deputy Sheriff Tony Garrett to the stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you. Please state your name for the convenience of the court.
My name is Stella Guthrie, Guthrie, and I am Deputy Sheriff Tony Garrett.
For the convenience of the court, my name is Nicola Hall, and this witness statement can be found on pages 33 to 37 of the mock trial case packet. Where are you employed?
I have been a deputy sheriff here in Burnsley for the past 20 years.
Do you know the victim, Eric Smith?
Yes, ma'am, I do.
Do you know the defendant, Jamie Colby?
Yes, ma'am. I have been called out many times about disputes between Colby and Mr. Smith.
Can you please tell the court about these disputes?
The first call was from about 4 years ago or so, and since then I have personally responded to about half a dozen or so calls from either Smith or Colby. They would complain about parking, vandalism, and excessive noise.
Did you respond to any calls from the victim in October 2020?
Yes. Last October, I responded to one of Mr. Smith's calls in which he suspected that Colby had broken into his house, ma'am.
What, if anything, did you do in response to this?
I provided Mr. Smith with a security camera from our department. I showed him how to set it up on a pole on the property and, with the motion detector, catch Colby coming into his yard through the gate.
Can you please tell the court what happened the morning of April 30th, 2021?
Yes, ma'am. At about 8:40 a.m., I responded to the report of a body at 46601 Raptor Road, which I knew to be Eric Smith's address. At the scene, I found a line worker by the name of Angel Russell standing next to Mr. Smith's body. Smith did not have a pulse.
What happened after that?
I then escorted the body to the hospital and returned to the scene, where I talked with Angel Russell, who had discovered the body.
Did you examine the mailbox?
Yes, ma'am.
And what did you find?
At that time, the mailbox was both open and empty. There was a slat that opened about 6 inches long and 1 3/4 inches wide on its top. Since the mailbox was closed before the victim had opened it, I wondered how the snake had gotten inside.
Objection, Your Honor. This witness is going to a narrative response.
The objection is overruled. The witness can continue unless the witness is done.
I am not finished, ma'am. Sorry, Your Honor. Knowing what I knew about the two neighbors, I believe that the snake bite may have not been an accident. I then photographed the mailbox, lifted fingerprints from it, and retrieved the body of the dead snake. Then I went to investigate the home of Mr. Smith.
What, if anything, did you find in Mr. Smith's home?
I found 3 envelopes which all contained rent checks from all of Smith's renters except for Jamie Colby.
What happened next?
I then spoke to Jamie Colby and asked if they had seen or heard anything in relation to Mr. Smith's death, and Colby responded with no.
Did Colby say anything else?
Colby said that they had been gardening the morning before and had an animal trap looking to trap pests. Colby also admitted that they were carrying a trap when they went to drop off their rent in Mr. Smith's mailbox.
What was your next course of action?
I then interviewed Terry Edwards, Francis Yazzie, and Danny Emling, all of whom are neighbors of Mr. Smith and Colby. I also reviewed the security camera video from 7 a.m. on the 29th of April.
Did you see anything on the security camera recording?
Yes, ma'am. The video showed Colby's backyard. On the ground, there were what I recognized to be snake tongs, which are tools that people use in the desert to grip deadly snakes from a safe distance. There was also a small, unidentifiable object laying next to the tongs.
What happened when you went to interview Colby?
Colby appeared jittery when I inquired about the death of Mr. Smith, cutting my questioning short, saying that they were very busy and asked if we could stop the interview. I received Colby's permission to take a look around.
Did you find anything when you looked around?
Yes, ma'am. I saw books about venomous snakes and other poisonous desert animals, in addition to a small tub with what appeared to be around 5 rattlesnake rattles and a vial of liquid that was labeled anti-venom.
Did you ask Colby specifically about the snake tongs?
Yes, ma'am. Colby said that they had sold some of their tools, including their snake tongs, humane animal trap, hunting knife, and other tools.
Did you see anything else of importance on Colby's property?
Yes, ma'am. In the garage, I saw a table with a pair of animal handling gloves, a long sleeve shirt, thick-skinned boots that were meant to protect against most snake bites. I also saw a large canvas tool bag that appeared to be empty.
Did you take any other action in this investigation?
Yes, ma'am. On the 31st of May, I received the report from forensics identifying the fingerprints found on the mailbox. They belonged to Colby, Smith, and Danny Emling. I also interviewed all of Smith's renters and determined that they were not involved in the death of Mr. Smith.
What action did you take?
Based on the evidence I
Objection.
collected,
Your Honor, this question is vague and ambiguous.
Your Honor, may I be heard?
Yes.
Your Honor, I am just trying to see what the witness, Deputy Sheriff Tony Garrett, did in their investigation. I am just asking a question, and if they are able to respond, they will answer the question.
All right, if the witness can't respond to the question, they'll let us know. I'll overrule the objection.
based on the evidence that I've collected, I arrested Jamie Kobe on the 3rd of June of 2021.
Thank you. No further questions at this time, Your Honor.
All right, thank you. Defense cross-exam?
Yes, Your Honor. For the convenience of the court, my name is Nicholas Barrett. Good evening, Deputy Garrett.
Good evening.
You've responded to numerous disputes between Mr. Kobe and Mr. Smith. Is that correct?
Yes, sir, that's correct.
One dispute was about Mr. Kobe parking his car in Mr. Smith's driveway, right?
Yes, sir.
And another was in regard to Mr. Smith playing loud music. Isn't that true?
Yes, sir, that is correct.
Is it correct that all such disputes were non-violent in nature?
Yes, this is true.
And you would agree that this was a pretty childish feud, wouldn't you?
Yes, I would agree that it is childish, but I would not put it past either one of them to take further violence with it or further action due to their relationship.
Regardless, one time you responded to a call in which Mr. Smith suspected Mr. Kobe had broken into his home. Isn't that right?
Yes, this is correct, sir.
And isn't it true that due to this, you provided Mr. Smith with a security camera for the purpose of catching evidence against Mr. Kobe?
Yes, sir, this is correct.
And you were the one who suggested that Mr. Smith collect evidence on Mr. Kobe. Isn't that right?
I showed Smith how to do so. I would not say advised.
Well, it is accurate that you found no evidence of a break-in, right?
Yes, sir, this is correct.
So isn't it true in another instance, Mr. Smith trespassed on Mr. Kobe's property without giving my client, his tenant, the legal minimum of a 24 hours notice?
Yes, this is true, but I was not contacted by Mr. Kobe about this situation.
Well, regardless, Mr. Smith trespassed and you did not give Mr. Kobe a security camera, right?
This is correct.
Let's move on to the tragic death of Eric Smith. You are aware of the line worker, Angel Russell, right?
Yes, sir, I did interview Angel Russell, so I was quite aware of him.
And you did not see Angel Russell as a suspect in your murder investigation, right?
No, sir, I did not. Angel Russell had no motive to kill Eric Smith, while Jamie Kobe did have a deceased mother.
Let's move on to Mr. Kobe. Mr. Kobe immediately gave you full access to search his home, isn't that right?
Yes, sir, this is correct.
During which Mr. Kobe complied fully and entirely with all of your questioning, right?
Well, to some extent, I would not say fully and entirely. They did cut my questioning short in the middle of my inquiries.
And yet they answered all of the questions that you asked. Isn't that true?
All of the questions that I did manage to ask, yes.
Thank you. No further questions, Your Honor.
Any redirect?
No, Your Honor. May this witness please be excused?
Yes.
Thank you.
People may call their next witness.
Your Honor, before I proceed, the prosecution would like to request a time check for direct examinations.
The prosecution has 6 minutes and 34 seconds left for their direct examination, and the defense has 5 minutes and 43 seconds left for their cross.
Thank you.
The prosecution would like to call Terry Edwards to the stand.
Calling Terry Edwards to the witness stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, I do.
Thank you. Please state your name for the convenience of the court.
Good evening. My name is Cora Fisher, Fisher.
And for the convenience of the court, my name is Mira Narayan, and this witness's statement can be found on pages 40 and 41 of the mock trial case packet. May I proceed?
Yes.
Thank you. Ms. Edwards, could you please introduce yourself to the court?
Good evening. My name is Terry Edwards, and I'm a retired lawyer.
Did you know the victim, Eric Smith?
Yes, I lived down the road from Eric for about 10 years.
And do you know the defendant, Jamie Kobe?
Yes, I was there when Jamie and his mother moved in, and over the years I've become well acquainted with Jamie and his antics.
Did Mr. Smith and Mr. Kobe have a good relationship?
No, Eric wasn't the easiest person to get along with, but he certainly wasn't malicious. Jamie, on the other hand, had it out for Eric. He threw things in his yard, blocked his driveway, and even threw animal droppings on his porch.
Were you at Jamie's mother's funeral?
Yes, I ran into Jamie at the grocery store and he told me about his mother's recent passing. He also told me about the funeral on the afternoon of April 28th, so I decided to go and give my condolences. I dislike Jamie, but I don't need to take that out on his dead mother.
Did anything unusual happen at the funeral?
Besides the normal funeral proceedings, there was a bit of a scuffle between Jamie and Eric. Jamie was yelling at Eric to leave, saying things like, "You weren't invited here. My mom hated you."
Objection, Your Honor. Hearsay.
Response.
Your Honor, this falls under hearsay exception, admission by party opponent.
Thank you. The objection is overruled. Prosecution may proceed with the question.
Thank you. Were you able to finish?
No, I wasn't.
Please proceed.
Jamie was yelling at Eric, saying things like, "You weren't invited here. My mom hated you." And he even went so far as to yell, "You killed my mom."
Did anything happen after that?
Jamie clenched his fist, and I became concerned that he would resort to violence. So I stepped in and I suggested that the two separate and discuss this at another time. To this, Jamie said never and walked away.
Did you see Jamie again before Eric's death?
Yes, I was concerned about him, so I went to check in on him that evening, and I saw him in his garden. When I rolled down my window to talk to him, he screamed, "I am going to kill him." I told him he should get some rest, and he said he would after he finished an important task he was working on.
Does Jamie usually garden at dusk?
No, actually, it was quite odd. It's common knowledge to anyone living in the desert that snakes are more active at dusk.
Thank you. No further questions.
All right, cross-exam.
Yes, Your Honor. May I begin?
Yes.
Good evening.
Good evening.
You said in your witness statement that Mr. Smith and Mr. Kobe both didn't get along very well, correct?
No, the two didn't get along, but Jamie was the one who was throwing things in Eric's yard and blocking his driveway.
But you've also said specifically that Mr. Smith was angry with Mr. Kobe for not paying rent, despite knowing about Kobe's financial troubles and the exception under the pandemic moratorium, correct?
Yes, I did.
And none of the disputes between Mr. Smith and Mr. Kobe ever escalated into anything of criminal nature, right?
No, they didn't, but there were some nasty actions that were taken, especially by Jamie with the animal droppings in the front porch.
But they were mostly non-violent, childish actions, right?
They were non-violent.
And you attended Kobe's mother's funeral, correct?
Yes, I did.
And you have said that Mr. Smith's demeanor at the funeral was over the line, right?
Yes.
And when you stopped by Mr. Kobe's house after the funeral, he seemed to be emotionally drained, right?
Yes, I'm sure he had a very long day dealing with, the death of his mother.
And also, Kobe did some gardening work for you, right?
Yes, about a year ago. But he never finished the job.
And when Kobe requested more payment to finish the job, you refused to pay the amount that he requested, right?
Yes, he was asking to be paid before finishing a job I requested he do after taking quite a while to do what little of the job he had already done.
But you wouldn't pay him the money that he requested, right?
No, I wouldn't.
Thank you, Your Honor. No further questions.
All right, any redirect by the prosecution?
No redirect, Your Honor. May this witness please be excused?
Yes.
Your Honor, the prosecution calls Dr. Charlie Dunn to the stand.
Calling Dr. Charlie Dunn to the witness stand. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you. Please state your name for the convenience of the court.
My name is Mara Christian, and I'm Dr. Charlie Dunn.
Apologies. For the convenience of the court, my name is Nicola Hall, and this witness statement can be found on pages 31 and 32 of the mock trial case packet. Dr. Dunn, could you please introduce yourself to the court?
My name is Charlie Dunn, and I am the Chief Medical Examiner for Burnsley County.
What are your qualifications?
I attended medical school at the University of Central California and finished in 2005. I completed my residency, specializing in clinical toxicology, in 2009. In 2010, I completed a fellowship in forensic toxicology, during which I became familiar with venomous and poisonous animals.
What is your involvement in this case?
On May 31st, I began the autopsy of Eric Smith, a 70-year-old man.
What were your findings from the autopsy?
I found 2 puncture wounds consistent with a snake bite on the body's left wrist, and around the wounds, the skin was red and swollen. The heart had experienced epicardial hemorrhaging, which causes bleeding within the pericardium. Epicardial hemorrhaging is often a direct byproduct of the hemotoxins within the snake's venom, which causes red blood cell death and thinning of the blood. The kidneys also showed acute tubular necrosis, which is a kidney disorder that can lead to kidney failure. In most cases of death by snakebite, necrosis happens as a direct cause of the bite.
Do you have previous experiences with deaths due to venomous bites?
Yes, I've seen 3 deaths due to venomous bites, 1 from a snake and 2 from spiders.
Can you describe the symptoms Eric Smith would have experienced after the bite?
Based on the state of the body, Smith may have felt relatively fine, except for local pain in the left wrist and arm. However, as the venom spread throughout his body, Smith likely began to fall in and out of consciousness, but did not die instantly. It is a horrible, agonizing death. I would estimate that the victim succumbed to lethal envenomation and died between 3 and 6 a.m. on April 30th.
Were you asked to examine anything else for this case?
Yes, I was asked to examine the body of a dead Mojave rattlesnake.
What did you find when you examined this snake?
It was significant to me that this was a Mojave rattlesnake. The venom from this type of snake is 16 times more potent than other species of rattlesnake. Their venom contains neurotoxins, which cause swelling, paralysis, hemorrhaging, and ultimately death. It was 2 feet long and 2 inches wide at its widest point in diameter. I also noted that it was missing its rattle.
Have you reviewed Dr. Clay's report?
Yes, I have.
Do you agree with Dr. Clay's conclusion as the cause of Eric Smith's death?
No. Dr. Clay is not a medical doctor, yet they concluded that Smith most likely died from pre-existing conditions. This is not correct. Smith died from the snake bite. Clay never examined the victim's body. Nowhere in my report do I state that Smith died from pre-existing conditions.
In your professional opinion, what caused the death of Eric Smith?
Smith was killed by the snake bite and would not have been able to survive the bite, regardless of any underlying health conditions. The only way Smith would have been able to survive is if he had had almost immediate access to antivenom.
1 minute.
Thank you. No further questions at this time.
Thank you. Defense, cross-examine?
Yes, Your Honor. May I begin?
Yes.
Good evening, Dr. Dunn.
Good evening.
It's correct that you don't have a degree in herpetology, right?
No, but I have studied clinical and forensic toxicology, so I know quite a bit about venomous and poisonous animals, including snakes.
But you've never professionally studied their behaviors, right?
No, I'm not a behavioral expert. I know more about the toxins and what they do to the human body.
And considering the availability of medical care, death from a rattlesnake bite is pretty rare these days, right?
It is, but it definitely also depends on the potency of the bite and how close the victim is to a hospital. In this case, they were pretty far away from a hospital, so it's more difficult to get immediate care.
But in a case where a victim does receive antivenom soon after a bite, there's practically no chance of death if the antivenom is administered.
Yes, but it has to be almost immediate, and in this case, they were quite far from the hospital, and no one in town seemed to have it.
And in your statement, you say that about 7,000 to 8,000 people are bitten by venomous snakes annually, right?
Yes, but that is a large figure, and it doesn't account for the potency of the venom.
But again, out of these thousands, only about 5 people die, right?
Yes, but it really does depend on what kind of snake you are bitten by.
And snakes are also known, to your knowledge, to squeeze into tight places, correct?
Objection, Your Honor. This calls for opinion testimony from a non-expert on snake behavior.
May I respond, Your Honor?
Please.
Well, this expert is a medical professional, and the opposing counsel is right. This is not necessarily their main focus. In their witness statement, I can find the line if it's necessary, but they do talk specifically about just at least what they know about snakes, where they might hide in places like this.
Okay, thank you. Just because it's in the witness statement doesn't mean it's admissible. And I think the witness previously said she was not a behavioral expert, so I am going to sustain the objection. Thank you.
Thank you. And Dr. Dunn, you have also said that in most cases, necrosis happens as a direct result of a snake bite, but you've also accounted in your witness statement for the fact that sometimes a rattlesnake bite, the toxins can exacerbate already existing conditions.
Yes, that is true. But in the case of Eric Smith, I didn't find that it was because of pre-existing conditions. I found that it was a cause of the bite.
And as you testified just a few minutes ago, it could have also taken a while for Smith to fully experience the symptoms of the snake bite, right?
Yes, but just because the symptoms take a while doesn't mean that the internal happenings aren't becoming deadly, and he would have needed immediate care, which he did not receive in order to survive.
Right, but after the bite, Smith may have felt relatively fine, right?
Yes, he would have felt fine, but internally he would not have been fine.
But in your expert opinion, you might agree that this delay in symptoms could have led Smith into almost a false sense of security, at least right after the bite, while they felt pretty fine, right?
That's definitely true, but he definitely needed medical care in order to survive.
But he wouldn't have known this given that, or he may have felt fine, so he wouldn't have reasonably known that there was something going on inside of him, right?
That's true, but if you're bitten by a snake, you should seek help.
Thank you, Dr. Dunn. No further questions, Your Honor.
Thank you. Any redirect?
No, Your Honor. May this witness be excused?
Yes. Does the prosecution have any other evidence?
No, Your Honor, the prosecution rests.
Thank you. Is the defense ready to proceed?
Yes, Your Honor. The defense would like to call Francis Yazzie to the stand.
Calling Francis Yazzie to the witness stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I'm not sure if we can hear you.
Hello? Can you hear me now?
Yes, we can hear you now. Thank you. Please state your name for the convenience of the court.
For the convenience of the court, my name is Jocelyn Castillo.
And for the convenience of the court, my name is Isaiah Navarro. Good evening. Please state your name and occupation for the record.
Good evening. My name is Francis Yazzie. I used to own Blue Agave, but I unfortunately had to shut it down due to the pandemic. I now make a living selling watercolor landscape paintings and homemade jewelry and belt buckles.
What is your relation to this case?
I am the neighbor to both Eric Smith and Jamie Kobe.
Okay, let's talk about Mr. Smith. What were your experiences like with Mr. Smith?
I wouldn't say that I knew Mr. Smith too well. However, I did know that he had a reputation of being a not very kind and considerate person. The few conversations I had with him made me understand why.
And what were these conversations about?
Well, I was visiting Jamie's house a couple times when Mr. Smith turned the power off. These conversations were in regards to that. I told him that it was illegal due to the eviction moratorium.
And how did Mr. Smith respond?
Every time I asked him, he just ignored me.
Okay, thank you. Moving on, what was your relationship to Mr. Kobe?
Jamie is a really good friend of mine. We've been living down the street from one another for about a decade now, and we hang out regularly. We even considered going into business together.
Do you share any common interests with Mr. Kobe?
Yeah, Jamie taught me about this landscaping hobby over the pandemic, and he was always a very kind and patient teacher when he was teaching me about it.
Okay, thank you. Moving on, did Mr. Kobe live alone?
No, Jamie lived with his mother.
And as far as you know, what was their relationship like?
Jamie was a full-time, loving, and devoted caretaker for his mother, who was on oxygen. He refused to move away so he could stay close with her, and when she died, he was stricken with grief.
Did he do anything to comfort Mr. Kobe after the passing of his mother?
Yes, after the funeral, we had our usual cup of tea at my house, and I did my best to comfort and console him. And I tried to help him process his feelings, but he just told me that he wanted to unwind in his garden.
Can you please describe Mr. Kobe's demeanor after the funeral?
After the funeral, Jamie seemed to be in an agitated state, and I believe it was because of the interaction he had with Mr. Smith at the funeral, that after he left my house, he seemed to be back to his usual calm, collected self.
Can you please elaborate in regards to this aforementioned interaction between Mr. Smith and Mr. Kobe?
Yeah, Eric made a very inappropriate comment about Jamie's mother's death, which only seemed to send Jamie further into mourning.
Thank you. And finally, did Mr. Kobe say anything to you once he had calmed down?
Jamie just laughed the whole situation off and just said it was Eric being Eric.
Thank you. Thank you, Your Honor. No further questions.
All right. Cross-exam by the prosecution.
Yes, Your Honor. And again, for the convenience of the court, my name is Elise Garza. Good evening, Miss Yazzie. You've known Jamie Kobe for just about a decade. Is that correct?
Yeah, I've known Jamie for a decade.
So you would consider Jamie Kobe a good friend of yours. Is that right?
Yes, I would consider him a good friend of mine.
You also knew Eric Smith?
Not too well, but I did know of him.
You didn't like Mr. Smith, did you?
Well, we only had a few conversations, so I can't really have my input on that. However, I did know that his reputation wasn't very good.
You believe Mr. Smith to be a jerk, do you not?
Yeah, sure.
You were aware of the ongoing conflict between the defendant and Eric Smith.
Somewhat.
You knew that the defendant blamed Mr. Smith for his mother's death.
That is correct.
Objection, Your Honor. This question calls for speculation.
Overruled.
Thank you, Your Honor. Now, you described Jamie to the police as gentle and kind. Is that right?
Yeah, Jamie was a kind and gentle person.
Were you aware that the defendant would throw things into Mr. Smith's yard?
Not too well.
Did you know that the defendant would make tire tracks in the victim's yard?
Yeah. I didn't know the full details.
Were you aware of the fact that Kobe would purposely park his car to block Smith's driveway?
No.
And did you know that Kobe would leave coyote feces on Smith's doorstep?
No, I did not.
Were you aware of the deteriorating relationship between the defendant and Smith and the unneighborly actions that took place on both sides?
Not too well.
Well, considering these facts and Jamie Kobe's actions towards Eric, is your opinion of Jamie Kobe at all changed?
No, I still believe that Jamie is a good person and a gentle person.
Thank you. No further questions at this time.
Any redirect?
Yes, Your Honor. Ms. Yazzie, while you were aware of all of the aforementioned events, it is true that Mr. Kobe, to your knowledge, never committed any acts of violence toward Mr. Smith, correct?
Yes, that is correct.
Thank you, Your Honor, for the questions.
All right. Thank you. Defense may call its next. Oh, witness may be excused. Defense may call its next witness.
Your Honor, the defense would like to call Danny Emling to the witness stand.
Calling Danny Emling to the witness stand. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you. Please state your name for the convenience of the court.
For the convenience of the court, my name is Aidan Bajan.
For the convenience of the court, my name is Nicholas Barrett. Please state your name for the record.
My name is Danny Emling.
What is your relation to this case?
I'm both the neighbor of Eric and Jamie, and Eric's my landlord.
What was your relationship like with Mr. Kobe?
Well, I knew Jamie as a really even-tempered person. He was very skilled at gardening, and he'd often come vent to me to cool off.
How about Mr. Smith?
Mr. Smith, he was rude and critical to everybody. We've had arguments in the past about rent, or when he blared music obnoxiously loud, but they never escalated to anything.
What did you notice about Mr. Kobe's relationship with your landlord?
The two argued pretty often, usually about Eric being rude or rent, but I always saw Jamie apologize or afterwards.
How did Mr. Kobe respond to these conflicts?
If they were particularly disruptive, he would call the sheriff or go apologize to Eric directly. Yeah.
So speaking of Eric Smith, were your fingerprints found on Mr. Smith's mailbox?
They were.
When was the last time you had touched it?
I mean, last time I dropped my rent check off, I didn't touch it at all. So the fingerprints found must have been from in the past.
Now, let's talk about your knowledge as a resident of Burnsley. Is it common knowledge that wild rattlesnakes are native to the area?
Yeah, everyone that lives here knows that they crawl into little tiny places and you've got to be really careful.
Is it also common knowledge in Burnsley that wild rattlesnakes often crawl into small spaces?
Yes, yes.
So does it seem unusual to you that Smith died from such an encounter?
Yes, everybody knows to get medical attention right away. I mean, rattlesnakes are usually not deadly if you get medical attention.
Thank you, Mr. Emling. No further questions, Your Honor.
All right, thank you. Cross-examination?
Yes, Your Honor. For the convenience of the court, my name is Nicola Hall. You are the neighbor of Jamie and Eric, correct?
Yes.
And Eric is your landlord?
Yes, he is.
You witnessed arguments between Jamie and Eric, right?
I did. Pretty frequent. They're usually petty, though.
You stated that Jamie could be angry when fighting with Eric, yes or no?
They both could be angry at each other. That's what a conflict is.
You saw Jamie leave some animal waste on Eric's front porch, yes?
That was one of the more childish things he did.
You were at Jamie's mother's funeral and saw an argument there between Jamie and Eric, yeah?
Yeah.
Objection. Your Honor, this question is outside the scope of cross-examination.
I think we're on cross-examination.
I'm trying to say that in my direct examination, I didn't once mention this funeral, and thus this question does not pertain to the cross-examination of this witness.
I see. Response?
Your Honor, I am just asking questions that this witness has experienced. It is within the scope of my questioning.
All right, the objection's overruled. Thank you.
Could you please finish your answer?
Yeah, I did.
Okay. You heard Jamie yelling that Eric had not been invited and should leave?
Yeah, it wasn't right that he was there.
So Jamie was angry?
I mean, reasonably so. He always cools off afterwards, though. I know Jamie.
You heard the defendant scream that Mr. Smith had killed his mother?
No.
You left town right after the funeral, correct?
I did, yeah.
So you did not see Jamie between the funeral and Mr. Smith's death?
I did not.
So you have no idea if Jamie cooled off between the funeral and Mr. Smith's death?
I wasn't there, but I mean, if you want my opinion, he usually cools off afterward, after the complex with Eric. So
You only learned about Eric's death when Deputy Sheriff Tony Garrett called you.
I did. Very surprising that somebody would die from a rattlesnake bite.
Thank you. No further questions.
All right, any redirect?
No, Your Honor. May this witness be excused?
Yes, thank you.
Your Honor, the defense would like to call Dr. Tyler Clay to the witness stand.
Calling Dr. Tyler Clay to the witness stand. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you. Please state your name for the convenience of the court.
My name is Malia Moreno.
And for the convenience of the court, my name is Samantha Wickham, and this witness's statement can be found on page 49 of the case packet. Good evening. Please state your name and occupation for the record.
My name is Dr. Tyler Clay, and I am the director of the Southland Zoological Museum in California.
What qualifications do you have to testify today?
In 2002, I received a Bachelor of Science degree at Central State University in California, and also a PhD at the University of Central California in biology with a specialization in herpetology, the study of snakes. I have recently published a book, The Snake Whisperer: Life Among the Snakes, and I've also worked as a resident naturalist at a couple of different national parks.
And regarding this case specifically, what have you examined?
Regarding this case specifically, I examined the medical examiner's report concerning Eric's death, as well as the Mojave rattlesnake specimen that bit Eric Smith.
And you said you specialize in studying snakes. Can you explain how likely it is for a person to be killed by a rattlesnake?
Though the Mojave rattlesnakes are highly venomous, their bite rarely kills humans due to the fact that the antivenom is so widely available, and when administered properly, it will save a victim's life.
So, what are the dangers that lead people to die from rattlesnake bites?
Serious symptoms of a bite do not manifest until hours after the bite, luring victims into believing that the bite is not as serious as it actually is.
So, in this case, why was the rattlesnake bite fatal for Mr. Smith?
Ultimately, the snake bite was fatal for Mr. Smith due to a combination of intervening factors, their actions taken after the bite, and the fact that they did not seek out the necessary antivenom. But such cases are uncommon.
Can you explain how pre-existing conditions can contribute to the results of a rattlesnake bite?
I have seen a few cases where victims of a snake bite show signs of acute tubular necrosis, which indicate of an underlying kidney condition. This condition can exacerbate the effects of the snake bite, allowing the neurotoxins to have a greater effect. But obviously, it is still the snake bite itself that led to this death. Even if a victim has pre-existing conditions, the antivenom would be just as effective as long as the antivenom is sought out. Death is no more likely than giving the availability of medical care.
And being a citizen of the desert yourself, would you say that most people are aware of the dangers that snakes pose?
Yes, most people are aware of the threats of snakes, such people are often cautious when opening tight spaces such as a mailbox, and it's not uncommon at all for residents of the desert to own antivenom themselves.
And is it likely for rattlesnakes to fall off of, rattles to fall off of Mojave rattlesnakes naturally?
Snakes missing their rattles are actually a lot more common than most people think. Snakes frequently shed their skin, and to aid this process, they rub up against rough surfaces or rocks, and this can actually inadvertently lead a snake to pulling off their rattle.
And would placing a snake in a mailbox be a safe task?
Attempting to capture a snake and then place it into someone's mailbox from a trap would be an incredibly dangerous task, even with the proper equipment.
And what are some of the reasons a snake might enter a small space such as a mailbox?
It is not unusual for snakes to hide out in dark places during the day to get out of the sun, but also they often seek out hiding places to wait later to hunt for their prey.
So, to elaborate, is it common for snakes to be found in small spaces like a mailbox?
Snakes are masterful at finding and squeezing into hiding places such as a mailbox, and I have personally seen many cases of snakes who found their way into mailboxes and then were found to much the surprise of the owner just trying to simply retrieve their mail.
Thank you, Dr. Clay. No further questions, Your Honor.
Thank you. Cross-exam?
Yes, Your Honor. For the convenience of the court, my name is Nicola Hall. Dr. Clay, you are neither a medical doctor nor a forensic pathologist. Is that correct?
No, but I've dedicated my entire career to studying snakes, and I am well versed.
And you never examined the victim's body. Is that correct?
No, but I did examine the medical examiner's report.
So your opinion as to cause of death is exclusively based on the medical examiner's report?
No, I mean, I got the information about the victim from the report, all pointing to the snake bite. But yes, yeah.
The Mojave rattlesnake that killed the victim is the most venomous rattlesnake in North America, yes or no?
Yes, but there is no guarantee of death because of the medical care these days and the internet.
The Mojave venom contains neurotoxins that can make the victim have difficulty breathing, loss of vision, and muscle spasms, and cardiac arrest can result, yes or no?
Yes.
Dr. Clay, you conclude that Eric Smith did not die of the rattlesnake bite, correct?
Could you repeat the question? Sorry, I couldn't hear you.
Dr. Clay, you concluded that Eric Smith did not die of the rattlesnake bite, correct?
Correct.
You concluded that Eric Smith died of pre-existing kidney disease and congestive heart failure, correct?
No, he died. These intervening factors exacerbated his death, and the snake bite exacerbated the intervening factors that caused his death.
Your Honor, may I direct the court to page 50, line 23 through 26. Although the snake bit Eric and there was no immediate medical attention, it is more likely that Eric's death was due to his pre-existing kidney disease and congestive heart failure.
Objection, Your Honor. This line is kind of taken out of context. The whole witness statement as a whole is saying that the pre-existing conditions exacerbated the snake bite, and if you look at lines,
So counsel, I'm just going to interrupt you. Why don't you save this for redirect?
Okay.
And I'm not sure what counsel for the prosecution is asking of the court. I'm happy to take note of that statement.
Yes.
Statement. I think you might want to be asking the witness if isn't it true that they made that statement in the witness statement?
Yes. Isn't this your statement?
Yes.
Thank you. You are aware that nowhere in Dr. Dunn's report did they state that Eric Smith even had congestive heart failure, correct?
Yes.
And nowhere in Dr. Dunn's report did they state that Mr. Smith had pre-existing conditions?
Wait, sorry, could you repeat? Sorry, my sound is kind of off, funny.
Okay. Nowhere in Dr. Dunn's report did they state that Mr. Smith even had pre-existing conditions, correct?
Yes. Yeah.
Yes. You have only seen a couple of cases of snakes in mailboxes in your 20-year career. Is that correct?
Yes.
Thank you. No further questions.
All right. Would the defense like to redirect?
Yes, Your Honor. If I may direct the court to lines 28 through 30 of the witness statement, it says that it is extremely unlikely that the Mojave Rattler's venom would have killed Eric Smith if he had gotten treatment for the snake bite. So to ask you, Dr. Clay, can you explain what was the role of the pre-existing conditions in the death of Mr. Smith?
The pre-existing conditions in the role of the death of Mr. Smith exacerbated the snake bite and leaving him. That was ultimately, the snake bite did lead him to die, but the pre-existing conditions factors made the bite worse, and that's helped the. Yeah.
But if Eric Smith was not bitten by a rattlesnake, would these pre-existing conditions have resulted in death?
Yes.
Thank you, Your Honor. No further questions.
All right. Thank you. This witness is excused and defense may call their next witness.
Your Honor, the defense would like to call Jamie Kobe to the witness stand.
Calling Jamie Kobe to the witness stand. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, I do.
Please state your name for the convenience of the court.
For the convenience of the court, my name is Aaron Buchanan.
For the convenience of the court, my name is Nicholas Barrett, and this witness statement can be found on page 42 of the mock trial packet. Please state your full name and occupation for the record.
My name is Jamie Kobe, and I used to be a server at a local restaurant called the Blue Agave until the pandemic hit. And since then, I've only been able to do my freelance gardening work.
Did the pandemic affect your income?
Yes, as I said before, I lost my job and work has been incredibly difficult to come by. I've rarely been able to pay my rent in full, and the unemployment we got and the disability that my mom received was our only consistent income.
How did you know Eric Smith?
Eric was my landlord for the past decade, for the entire time I've lived in Burnsley.
Describe the nature of your relationship.
Eric and I did not get along very well. I thought they were an inconsiderate landlord, and they clearly wanted me to leave, especially since the pandemic started.
How did your struggle to pay rent affect your relationship with Mr. Smith?
It was just another issue in a long line of petty disputes. They clearly wanted me to leave, but couldn't kick me out because of the eviction moratorium.
So, aside from these disputes, did anything else harm this relationship?
Yes, recently my mother passed away, and at her funeral, got into an argument with Eric that was in poor taste. I was angry at him, but mostly I wanted to be left alone to mourn.
Did anything help you with your grief on that day?
Yes, I met with my friend Frances for tea, and I talked with her, and she really helped me process everything. And after that, I went home to garden and relax a bit more.
Could you tell me a bit more about your gardening?
Yes, I love it. It's my passion. I do a type of gardening called xeriscaping, which involves low water usage. You could see why this is helpful in the desert.
What, if anything, happened while you were gardening after you met with Miss Yazzie on April 28th?
Well, I originally got mad about some pests that were eating away at my garden and yelled a bit at them. And then I saw that Terry Edwards, one of my neighbors, had come by to talk. I vented to them for a little bit, but they left pretty quickly.
Can you tell the court about the events of the morning of April 29th?
Yes, I dropped off my rent check and then went to sell some gardening tools to pay for my mom's funeral.
How did you become aware Eric Smith had died?
I was informed by Officer Garrett of their death.
Did Officer Garrett search your home on that day?
No, not originally. They came by a day later to investigate more,
30 seconds.
What did they ask you about?
They asked me about my relationship with Eric and some gardening tools I owned.
Finally, were you involved in the death of your landlord, Eric Smith?
No, God, no. The last thing I could want is more death. This entire pandemic has been a waking nightmare, and I just want these tragedies to end.
Thank you. No further questions, Your Honor.
Thank you. Cross-exam.
Yes, Your Honor, but before I proceed, may I request a time check for cross-examination?
Yes, the prosecution has 3 minutes and 33 seconds remaining.
Thank you. And for the convenience of the court, my name is Mira Narayan. May I proceed?
Yes.
Thank you. Mr. Kobe, you have a history of vandalizing the victim's property, correct?
I've never been charged with anything, but I threw poop over there once.
You also blocked his driveway on multiple occasions?
Yes,
And it drove over his yard, leaving tire tracks?
I did once, yeah.
Your mother was on an oxygen machine, correct?
Objection, Your Honor, lack of foundation.
Response?
Your Honor, may I inquire as to the foundation the defense would like?
The question was, your mother was on an oxygen machine. How does that lack foundation, Mr. Barrett?
The previous questions have been about the interactions between Mr. Smith and Mr. Kobe, and opposing counsel skips to Mr. Kobe's personal life with lack of foundation to understand this question.
All right, thank you. The objection's overruled. The witness may answer the question.
Yes, my mother was on an oxygen machine before she died.
So when Smith shut off the power, therefore shutting off your mother's oxygen machine, he led to your mother's death?
Yes, but mostly it was the illness. It was only a matter of time.
But at your mother's funeral, you explicitly yelled at him, "You killed my mom." Isn't that right?
Yes, when he showed up at the funeral and started asking me to leave, I just got angry at him. I just blamed him for something I never should have.
You were so angry that your neighbor Terry had to separate you?
He didn't need to separate us, but he did step in to ask us to stop arguing.
In fact, you were so angry that you had to leave your own mother's funeral, correct?
Objection, Your Honor, this question is argumentative.
Response?
Your Honor, I'm simply asking the witness to testify to the events that happened at his mother's funeral.
All right, I'm going to sustain the objection and ask you to please rephrase the question.
Thank you. You left your mother's funeral after your argument with Eric Smith, correct?
Yes, the funeral was over.
Thank you. You had books on venomous snakes in your house, correct?
Yes, along with a lot of other gardening topics.
And you were at Smith's mailbox the day before his death?
I was to drop off my rent check.
And referring your attention to Exhibit E, you were carrying this humane animal trap?
Yeah, I was going to go try and sell it.
You have testified previously that you went to Eric's mailbox to drop off your rent envelope, correct?
Yes, that's what I said.
Thank you. You would pay rent every few months as a sign of good faith?
Yes, and especially this time I was hoping it would calm things down between us.
Thank you. No further questions, Your Honor.
All right, any redirect?
Yes, Your Honor, but before I proceed, the defense would like to request a time check for our redirect.
Yes, the defense has 6 seconds remaining.
May I proceed?
Yes.
Mr. Kobe, were your interactions with Mr. Smith, your disputes, were they ever violent?
No, never.
And these disputes?
Time has run out. Please stop.
Thank you, Your Honor. May this witness be excused?
Yes, thank you very much. All right, we are now at the time for closing arguments. Oh, excuse me, let me just clarify. Does the defense now rest?
Your Honor, the defense rests.
Thank you. All right, and so the prosecution may present its closing argument.
Your Honor, before I proceed, may Exhibit E be entered into evidence?
I believe the only exhibit you asked to be admitted during your case before you rested was Exhibit C. So that is the only exhibit that will be admitted.
Okay, thank you. For the convenience of the court, my name is Mira Narayan. Revenge is a powerful motive. It can lead people to commit crimes that they would have never previously considered, including murder. This is what happened to Jamie Kobe. Jamie Kobe committed murder. This was not an accident or a crime committed in the heat of passion. Murder is an unlawful killing of a human being with malice aforethought. And CalCrim 521 defines first-degree murder as a murder that was willful, deliberate, and premeditated. All of these elements have been proven beyond a reasonable doubt. Your Honor, the defense is claiming that the rattlesnake climbed into the mailbox on its own. However, Deputy Sheriff Tony Garrett has testified that the mail slot was only 1 3/4 inches wide. The snake that bit Eric Smith was 2 inches wide. Dr. Clay also admitted that she has only seen a couple cases of snakes in mailboxes in her 20-year career. The hypothesis that the rattlesnake crawled into Eric Smith's mailbox through the slot in the top by sheer coincidence does not hold up, even by the standards of the defense's own expert witness. On the morning of April 29th, the line worker Angel Russell observed Jamie Kobe walking towards the mailbox carrying his humane animal trap and looking down at it repeatedly. Why would he carry a heavy cage and a bulky bag of gardening tools just to drop off his rent? Why would he look down at the cage repeatedly if it was empty, as he claims? He was looking at the cage because it contained the rattlesnake, and he was carrying the bag because he needed snake-proof gear to transfer the snake into the mailbox. What Kobe did not know was that Angel Russell saw him walking to the mailbox, and Angel Russell has given us key evidence of Kobe's actions. Kobe claims that he went to the mailbox to give Smith his rent, but this cash and the envelope it supposedly came in was nowhere to be found when Deputy Sheriff Tony Garrett investigated the scene. Envelopes from all of his other tenants were. Furthermore, we know that Kobe was angry at Smith from his outburst at the funeral. "You killed my mom." Kobe said that he paid rent every few months as a sign of good faith. Realistically, why would he be trying to extend an olive branch to the man who killed his mother? He went to the mailbox for only one purpose: to hide the snake in the mailbox. This is further proven by the fact that on the night of the funeral, Terry Edwards saw Jamie in his garden and heard him yell, "I am going to kill him." He also told Miss Edwards that he would go to sleep after he finished an important task. What was the important task? Kobe needed to catch the rattlesnake, the weapon in Smith's murder. "You killed my mom." Kobe claims that he was in a tense situation and wasn't thinking clearly, that Eric Smith's day the very next day was just a
minutes.
Your Honor, Jamie Kobe meant every word that he said. "I am going to kill him." We know that the defendant intended to kill. He admitted that he has an extensive knowledge of desert snakes. He had books about snakes and even anti-venom in his home. He also had his animal trap, snake gloves, and high leather boots. He knew that the Mojave rattlesnake is one of the most dangerous desert snakes. In fact, it is 16 times more deadly than any other species of rattlesnake. He knew that the hospital is at least 45 minutes away, and that Eric Smith would not be able to get anti-venom in time, as Dr. Charlie Dunn confirmed. And he knew that Smith would experience an agonizing death, just like his mother had when Smith turned off the power. The defense may argue that the defendant was provoked by Smith. However, in order for a sudden quarrel from a state of passion to reduce a murder to voluntary manslaughter, the defendant must have acted under the direct and immediate influence of provocation. It must be a decision to kill made rashly, impulsively, or without careful consideration. This was a meticulous plan, carried out with extreme caution. The defendant was not acting impulsively or rashly. He was thinking clearly, and he knew the consequences of what he was going to do.
30 seconds.
"I am going to kill him." Your Honor, Jamie Kobe committed first-degree murder. His killing of the victim was willful, deliberate, and premeditated. The only just verdict is guilty. Thank you.
Thank you. Is the defense ready to give its closing argument?
Yes, Your Honor, but before I do, the defense would request a time check for our closing argument.
The defense has 5 minutes and 17 seconds left for their closing arguments.
Thank you. May I proceed?
Yes.
A humble gardener, a teacher, a friend, and a murderer? Your Honor, one of these is not like the others. Jamie Kobe is not a killer. He's a peaceful man with a simple hope. All I want is for these tragedies to end. Your Honor, amidst the pandemic, Mr. Kobe endured the worst, and he kept going. When his only source of income vanished, Mr. Kobe turned a passion for plants into an occupation. When my client's beloved mother passed away, a grief-stricken Jamie Kobe turned to neighbors and friends to process his loss in a healthy way. Now, when his landlord Eric Smith tragically and unexpectedly perished due to a wild rattlesnake bite, Mr. Kobe turns to you to plead innocence in a crime he did not commit. Your Honor, to warrant a guilty verdict, the prosecution must uphold their burden of proof. that beyond a reasonable doubt, each and all three requirements of Cal Crim 521, first-degree murder, must be met. That my client caused Eric Smith's death willfully, deliberately, and with premeditation. Mr. Kobe's closest confidant, Francis Yazzie, told you that after the outburst at the funeral on April 28th, their friend Jamie sat down for tea, talked through his emotion, and, quote, calmed down. When he left Miss Yazzie's, Mr. Kobe knew the sad truth. He could not blame Eric Smith for his mother's passing. She had been sick for years. It was only a matter of time. The prosecution claims, contrary to what you just heard to be true, that Mr. Kobe declared that evening he was going to kill Eric Smith. But the fact is, Miss Edwards misheard Mr. Kobe. After an exhausting day away from his garden, Mr. Kobe returned that evening wanting to enjoy the catharsis of gardening, only to find snails and pests all over his award-winning plants. "I'm going to kill them," he said, as the bugs ate away at the garden he had spent years maintaining. Mr. Kobe is not a killer. He did not want revenge, and he could not have known a snake would kill. Your Honor, Dr. Dunn and Dr. Clay testified that due to the wide availability of antivenom, it's extremely unlikely for anyone to die of a snake bite, much less be murdered by one. Mr. Emling knows these facts to be, quote, common knowledge to everyone in Burnsley. Clearly, Mr. Kobe knew Mr. Smith likely owned antivenom. Your Honor, on April 29th, line worker Angel Russell was only 100 meters away from Mr. Kobe and saw exactly what my client was wearing and exactly what he was carrying. Always averse to violence, Mr. Kobe gave his landlord a rent check that day to ease tensions and relax this very stressful situation. What Angel Russell did not see that day was a rattlesnake, snake handling tools, or a snake being placed into a mailbox. Why the prosecution claims Mr. Kobe had these tools in his bag, and they want you to believe that my client stood by the mailbox, only then to open the tool bag, put on the thick gloves, take off his shoes, lace up the snake-proof boots, open the heavy trap, and force a wild snake into a mailbox, all the while in the clear line of sight of potentially both Mr. Russell and Mr. Smith. Not to mention, Dr. Clay's testimony suggests this would be an incredibly dangerous task even with the proper equipment. Neither Mr. Russell or Mr. Smith saw anything like this. Why? Because Mr. Kobe never had these items. He never put a snake in a mailbox and never once harmed Eric Smith. The prosecution tries to diminish Dr. Clay's expertise by saying she has not seen many snakes in mailboxes. But the experts have testified rattlesnakes seek out enclosed spaces for a variety of reasons, including to get protection from the sun or predators. And Dr. Clay, who studies snake behaviors, knows snakes are masterful at squeezing into the smallest spaces. And she has seen many cases of snakes in similarly small spaces. Dr. Clay also explained rattlesnakes often lose their rattles on their own in the wild. These facts of science are indisputable. Lastly, direct your attention to Deputy Garrett, who did not conduct a full investigation of this trial. Deputy Garrett gave Mr. Smith a surveillance camera to collect evidence on Mr. Kobe due to a baseless accusation of a break-in. When Mr. Smith trespassed on Mr. Kobe's property, the deputy offered no assistance. Her bias shows that the deputy's account of the facts in this case cannot be trusted. With no proof of ill intentions and no credible evidence of murder, you'll see the much more likely conclusion in this case. Eric Smith died as a result of a tragic accident in which a rattlesnake entered Mr. Smith's mailbox through the opening on the top, and later it attacked. After the bite, Mr. Smith unexpectedly perished when he refused to seek out antivenom or medical attention. Thus, with the overwhelming amount of doubt in this case and the prosecution's failure to meet their burden of proof, there is only one
Time has run out. Please
not
stop.
guilty.
All right, thank you very much. The prosecution has 1 minute for rebuttal argument.
May I proceed?
Yes.
Thank you. Your Honor, opposing counsel brings up the point that snakes like to hide in cool, dark spaces. We are not disputing this. However, this does not apply to Smith's mailbox, as it has been stipulated that the inside of the mailbox and the temperature outside were the same. The defense also brings up the point that deaths rattlesnake bites are very rare because antivenom is widely available. However, Mojave rattlesnakes are one of the most venomous rattlesnakes in North America. Kobe also knew that Smith would not be able to get antivenom in time because the hospital is 45 minutes away. Not only is Smith's refusal to get medical help not an excuse for murder, it would not have mattered, as he would have not been able to get medical help in time. Your Honor, the only just verdict is guilty of first-degree murder. Thank you.
Thank you. And now the defense has 1 minute for rebuttal.
Yes, Your Honor. May I proceed?
Yes.
Your Honor, the prosecution tries to paint a story of a furious Mr. Kobe. However, all character evidence in this trial showed that he relaxed after the outburst at the funeral. He did not blame Mr. Smith for the death of his mother, and he calmed down. Your Honor, many people in Burnsley own antivenom. They're in the desert. They know the dangers of snakes. Also, Dr. Clay has shown you that snakes go in all sorts of small spaces. The largest snake can fit in the smallest space. And Your Honor, the mailbox in question is part of the desert. It's in the desert, just like Mr. Kobe's home and Mr. Smith's home. So it is no unreasonable conclusion that a snake could have gone in this mailbox. Your Honor, the much more reasonable conclusion is that Mr. Smith died of a tragic accident, which could have been prevented if he had only used his
Time has run
antivenom.
out. Please stop.
Thank you.
All right, thank you. All right, before I render a verdict, students may confer with their coaches regarding any trial irregularities. Would the prosecution team like to note any trial irregularities?
No irregularities from the prosecution, Your Honor.
And how about the defense?
None, Your Honor.
All right, thank you. It is time for the court to announce a verdict. In this matter, I'm going to find the defendant not guilty of first-degree murder and not guilty of voluntary manslaughter. And that brings us to the end. This was amazing. I'm just going to make a few comments and then turn it over to the scoring attorneys. As some of you know, I judged one of the first rounds in this competition this year, and one of the same teams was in that by happenstance. The improvement from then is just really incredible. The work that you've all done is really incredible. I could sit here and probably spend the next hour giving people both constructive criticism and accolades. So I try to just make it general, even though I know you're all dying to get specifics. So I'll give a few things and then turn it over to the scoring attorneys. But I really just have to say that you all did an incredible job. I mentioned at the outset, because of that first round where everybody spoke so quickly, I encouraged you to slow down, and almost everybody was slow and clear and loud and comfortable. And it was just a pleasure to observe the performances. So many people were just absolute professionals at all their roles. I'll just say for the pretrial arguments, be sure to answer the question that the judge asks. Take your time. Ask for it to be repeated if you need, but really try to answer that question, not what you're hoping the judge asks, but answer that question. But both of you had an incredible knowledge of the case law and of the arguments that you wanted to make, and you were both very persuasive. For the opening statements, I could see definitely a little bit of nervousness there. I want to just remind everybody that when you're in the real courtroom, how obvious it is that you're reading off of a piece of paper. And I know when you're on Zoom like this, it seems like you can kind of get away with it, but honestly, we can see when you're reading. And so I'll just encourage whichever of these teams makes it on to the next round, to the finals, which both of you deserve to do, in my opinion. Try to just get rid of those notes and not be reading, because we can actually see your eyes kind of moving across the screen, and it just feels less natural when you're reading off your notes. So both of you, please just keep that in mind. Gosh, the witnesses and their rapport with the attorneys, you can just see how many hours you've all spent with the relationships developing the back and forth. I did want to talk a little bit about some of the objections. I was so pleased to hear some of the objections other than hearsay. I was surprised to not get a few more hearsay objections, but it always makes me happy to see that students are learning more than just the hearsay objection. I thought that a lot of people, when their witness was being cross-examined by the other team, could have objected, or sorry, when they were doing a cross-examination to their witness, they could have objected to the opposing witness as being non-responsive to their question. And I know a lot of the questions were, please answer yes or no, and the witness wouldn't. So object, move to strike, non-responsive. I thought a few more people could have done that, but let's see. Yeah, all the witnesses were just so incredibly professional. The two experts really appreciated. I felt like this round, I learned a lot more. I mean, I read all the facts and everything, but the amount of detail and natural testimony that you gave about some things. And I really liked Dr. Dunn's description of how someone dies by snake venom. Also, I liked how Dr. Clay explained how a snake could lose its rattle. So those were really interesting facts that were brought out so much better this round, and I appreciated those. I really liked that the attorney, Ms. Hall, who was questioning Dr. Dunn, asked right away about the opposing expert's opinion and got that critique over it. I was waiting to see someone use a redirect, and finally that started happening, particularly in the defense case. I think it's really critical that you be ready to do that, to ask at least one redirect question of most witnesses. When you are the team that gets to have that last word, why not use it? So I was pleased to see the defense doing that a few times. On the objection, again, the beyond the scope of cross-exam, I think that was a great objection to know about. It was just misused a little bit. It's actually one that you would use when someone's doing a redirect, and that redirect goes beyond the scope of cross-exam. But you're so close to understanding these incredibly complex rules of evidence, and I just appreciated that you were willing to step out and make some of these less common objections. I also appreciated that almost every attorney doing a direct examination gave the page number of the witness statement. It's really critical for the presider to have that. Finally, let's move on to, one more thing on the objections. Mr. Barrett made that lack of foundation objection, and same thing, that lack of foundation objection is a really difficult one to understand, but boy, it could have been used a lot more in this trial, and it's more appropriate for someone who's doing a direct exam and the witness gives a fact that there hasn't been adequate background given for. So good job making that. Just learn it a little bit better so you make it at the right time next time. Mr. Barrett, your cross was just incredibly convincing. You got into it. It seemed like you were going without notes, and definitely a big part of my not guilty verdict this round. Ms. Narayan, you were just incredibly professional, and what really impressed me was that your rebuttal actually rebutted the points the defense made on their argument. It wasn't something that you had already written out, and I think that's what, all the scorers are looking for, those kind of things. So with those remarks, hopefully I kept it under my 3 minutes. I'm going to turn it over to our scoring attorneys for their remarks, and let me just introduce them by saying these attorneys have also put in a ton of time and effort into this. They've gotten to know this case. They've taken several hours of training. I know that all of them have done multiple rounds of scoring. Most of them have done this for years and years. You have former mock trial coaches here and people who are giving up their time because they love high school mock trial and they see the value in it, and they want to support all of you students who have taken on this incredible task. So I'm going to go ahead and just call on the scoring attorneys one by one. Let's start with Ms. Leslie Harris.
Good evening. Thank you, Your Honor. Well, I would echo what the judge has said. A really excellent trial presented by both sides. I was very impressed with some of the witnesses, which usually I don't focus on so much, but yeah, I would say Dr. Dunn, Mara Christian. That was a very professional, convincing, I thought technical delivery. And not only were you able to explain things very well in responding to the questions from your attorney, but you handled the cross really well in giving an honest response, but also elaborating in a way that maintained your position. I thought that was very, very good. And I give both you and your attorney credit for that, because I know it is a lot of work to prepare for that. The objections are always, I think, difficult in real life too. I find it, sometimes you're like, something's just, this isn't right. And so objection, and then doing your best to identify exactly what that is. And so I think your instincts were very good when you did object, and just kind of really understanding at that moment what is the most precise objection. I thought just generally the questions, and both on direct and cross, were very good. I felt like even though I saw this trial last week, that I learned new things. One thing I would say is that in this trial, the judge allowed the exhibit of the tongs to come in, and I didn't really hear anything about that. So I wondered if maybe the defense team or the prosecution, I'm sorry, hadn't expected that and didn't really incorporate it. So that was just one thing I was listening for, what the difference would be with that evidence being admitted. The closing arguments I thought were both very good and covered, marshal the evidence, address the law, address the burden of proof. Both sides very comprehensive, very persuasive. I did find Mr. Barrett's to be particularly good, and because I think the defense sort of had a bit of an uphill battle, and I really kind of agreed with the judge that he brought up some things that made you have some reasonable doubt. So one of the things was the prosecution, and I thought this was good, her theme of, I'm going to kill him, I'm going to kill him, I'm going to kill him. And then the defense having this, yeah, he was talking about bugs, so made me go, well, that could be, So anyway, really, congratulations just for making it this far. You all did a great job. I was engaged the entire time. Thank you for all that hard work and making it fun and interesting to watch.
Thank you so much, Ms. Harris. Let's hear next from Mr. Greg Pinato.
Your Honor, scoring attorneys and respective teams. Wow, what a great job. You guys really hit it out of the park. And I think you got to kind of step back and realize you're doing what grown-ups are doing in court every day, and you're doing it really well. So you should be proud of yourselves. Really, I've coached or scored for about 15 years. I coached Soquel years ago, and I know it's kind of nerve-wracking getting on the screen and practicing, and you can tell I'm kind of nervous addressing you right now. I mean, it's really exciting to be a part of this program, and I think you guys just really need to be proud of yourselves. You're doing a really sophisticated thing here, and I'm really proud to be a part of it. And you guys practice, I know, for months and months and months and months, and you're learning about cases and applying rules of law that we're dealing with in court every day, and you guys are doing it in high school. And not only are you doing it in high school, you're doing it when you have sports to play. You have a full, set of classes you're taking, theater, band, whatever it is, and you're adding this to the plate is just something really, really special. And you guys are really special kids. And I'm really proud. I'm proud to be a part of this. And you guys, again, I can't reiterate that enough, because I know throughout the process, you're then getting updates and there's a RADA and you got to fix line 26 on page 42 and you're changing it as the process is going. And then there's these tech issues. Are we doing it in person? Are we going to do it online? Do we have to wear masks when we're practicing? And just adapting. It's just really special. And so you guys did it seamlessly and you did it really, really good. And, you know, I think you guys should be really proud of yourselves. You guys really stepped it up a notch. I scored one of the other rounds, and you can tell that you guys are really, really polished. So really good job, everyone. Really good job. The one last thing I wanted to add is, you know, I really encourage you guys to go down to the courthouse and really go into a courtroom and see what we do every day, because it's really an interesting thing, whether it's criminal law or civil law. Just to see the process really at play, I think would add a whole new dimension and appreciation. And I encourage you to ask your coaches to take you down to the courthouse, or even just call the DA's office. Call me. I'd be happy to take you down to the court and give you a tour. You know, COVID's kind of crazy. I used to take, you know, students into our office. It's a little different now, but I'm sure any one of the attorneys that are coaching you would take you to court, and I'd be happy to do that. And so I really encourage that. And with that, just a round of applause on my behalf. And I know all the other attorneys and coaches. And coaches, you should be really proud too. Really proud of these students. I'm sure they've come a long way. And so thank you for allowing me to be a part of the process. Thank you, Your Honor.
Thank you so much. Let's hear next from Mr. Sam Forbes Roberts.
Hello, all. Yeah, I'll just echo. I think we were supposed to stay to 10 minutes on our comments, and we're about 15. So I could reiterate everything the judge told you, and Leslie and Greg, and I'm sure that Mike's going to tell you. But you know, great job. If you do go down to court and watch the grown-ups in court, you'll probably find that you're doing better than half of them already. So it'll probably give you, I mean, it'll give you a boost because you guys are operating at that level. You're having an understanding of the law, and, you know, you're working so hard, and it's apparent. I scored 2 times last week, and the improvement this week is just phenomenal. The judge said, you know, during pretrial to listen to what the judge asked and respond to that. Also listen to what the witnesses say. If they're not responding to your questions, sometimes, you know, you may be, you know, so tuned into a script or into the questions that you've written, you don't hear that they're not responsive. So that's just another little tip. I know that there's a lot of things that you're probably curious about to help you advance to the next level or win this competition or any other competition. And I believe that Denise or Sita said that there's a way, if anybody's interested in asking for some feedback for this year, for next year. I think we all probably took good notes on every single one of you, and I'm sure we would all be more than happy to help you out with that, or give our little bit of opinion. But great job, super honored to be a part of this, and you guys, you know, deserve all kinds of kudos and pats on the back for what you've done already. So thank you. Thank you.
Thank you so much. And Michael, is it Tuning? Am I saying that?
It is Tunic. It is Tunic, Judge Coleotti. Thank you.
Hi.
And thanks for giving me a few moments to comment. I just want to echo what the other scoring attorneys have said. What you're accomplishing here is really impressive. You're cramming into a semester what we lawyers put 3 years of law school into, and lots of mentoring and practice. So good job. It's really a privilege to be able to hear you. Now I'm going to get to some of my comments, and Judge Coleotti said, "Ooh, don't get caught looking at your notes." Well, I'm so sorry. I'm going to look down at my notes, so I'm busted in open court. But as Judge Coleotti said, both pretrial motion attorneys had very good knowledge of the law. Mia Beatty, I thought you had a very good pretrial. Your delivery was concise and direct, especially with regard to the 4 criteria of the curtilage test. And you did a good job responding to Judge Coliotti's questions regarding the opening in the fence and then the flyover question. And as your coaches have probably told you, distinguishing cases that might be harmful to you is really the key to success and that kind of thing. And Ms. Beatty, I thought you did a good job. Isaiah Navarro, in your opening statement, you did a good job of previewing what each witness would testify to and addressing the elements of the crime. And what I really liked about how you addressed the elements of the crime was in how you were injecting reasonable doubt as you addressed each element. Nicholas Barrett, on your first cross-examination, I thought you did a good job of framing the defendant's interactions with the victim as being nonviolent. That was good. I'll actually skip ahead, Mr. Barrett. So I went chronologically on my notes, but now that I see your name on your first cross, I'll skip forward to your closing. Mr. Barrett, your closing was really, really good. It was probably, if it's not the best closing I've heard in all my years of scoring, it was certainly up there at top. And what I'm about to say, I'll leave it to your coaches to address, but I would reconsider the use of the level of emotion in your closing argument. The text of it was perfect, but consult with your coaches about whether at the next level it states whether the level of emotion expressed is a good thing or not, and I'll defer to your coaches on that. Stella Guthrie, in your performance as prosecution witness Tony Garrett, I thought you had a good presence as a witness and did a good job of framing your responses on cross-exam to do the least damage to your case, which is a good talent. Mira Narayan, I thought you did an excellent job pulling out admission of a party opponent on the hearsay objection. I think there's a couple other hearsay exceptions you can use, but that was a really good off-the-cuff delivery there. And your direct of Terry Edwards was very efficient, and your cross-examination of the defendant was too. Cora Fisher, your portrayal of witness Terry Edwards was strong. When you had to concede something on cross-exam, you did while trying. So conceding on cross-exam is an important skill to do it when it can be done in the way that's least harmful to you. And I thought you did a good job of that. Nicola Hall, you had a solid performance throughout today's trial with truly no weaknesses. You had a strong directive, Charlie Dunn. You covered all the bases, and both your cross-exams were good. Samantha Wickham, I just want to encourage you that despite your objection regarding the expertise of the witness being sustained, it was a good objection, I thought, and worthy of being made. So don't let the sustaining of that objection get you down. Mara Christian, you had a good conversational delivery as a witness, and I really thought you did a nice job on two things that were important to your portrayal. Number one was addressing the contents of your report as compared to the other experts' report, and also you did a nice job of turning a negative into a positive regarding your qualifications. And I'm sifting through my notes. That's it. Thank you all for the privilege of letting me score your trial.
Thank you so much. Boy, again, just so impressed with everybody, so impressed with the coaches that supported these students and taught them, so impressed with the parents and families that supported these students. And then, boy, thank you so much to the scoring attorneys for all of their time. And you can just really feel the love they have for high school mock trial, as I've said, as do I. So whichever team comes out of this going to the finals, I wish you good luck. Whichever team doesn't, you did amazing. Don't be disappointed. This is going to be a close call. I have no idea which team it's going to be. And for those of you who are seniors that are graduating and maybe you've put in a couple years in this mock trial, good luck moving on in your lives if you're going off to college or whatever you're going to be doing. And those of you who are not graduating, I hope you're back next year so that we can see you live in the courtroom for High School Mock Trial 2023. I plan to be here. And that's about it. So have a wonderful night. And thank you all, and congratulations again on fantastic performances.